Good morning, Your Honor.
Good morning, sir. My understanding is that you are choosing to represent yourself, correct? You're choosing to represent yourself, correct?
I am pro se with advisory council. Yes,
Okay.
ma'am.
Did anyone give you information as to who that advisory council was going to be?
When I called at the time, they hadn't been appointed.
Okay. Do we have a list of who accepts advisory appointments? Okay, well, we'll go ahead and appoint him, and I'm going to be perfectly frank with you. The list of attorneys who accept advisory appointments is, it comes through the kind of the Office of the Public Defender.
Okay.
And there aren't as many attorneys as there used to be who are willing to accept advisory appointments. I do have an attorney who has been willing to accept appointments before. However, I also know that in the next few days, he will find out if he's been appointed as a county court judge. But I'm going to appoint him at this point in time. And then at your next court date, we will give you information as to whether or not he remains your attorney or whether we find out who that advisory council is going to be. Okay?
Sounds good.
Okay.
I'm
sorry.
Go ahead.
I just want to go on the record real quick.
Okay.
Okay, so I am Gregory C. Smith, Jr., appearing sui juris under the mandate of Article 6 of the United States Constitution. Pursuant to UCC 1-308 and Colorado Revised Statute subsection 4-1-308, I reserve all my rights under the United States Constitution, including the 8th and 14th Amendments, Colorado Constitution, Article 2, subsection 7 and subsection 20, the United States Code, and Colorado Revised Statutes 18-1-504 and subsection 18-6-800.3. I acknowledge the appointment of advisory counsel to assist only in procedural research and technical filing. I remain the lead inquisitor and authorized representative. This appearance is restricted to challenging jurisdiction and procedural defaults and does not constitute a general appearance or consent to the court's jurisdiction of my private person. And I'm here to address the following, which would be the sufficiency of probable cause, specifically regarding the knowing element, the domestic violence designation, Rule 41E, property concerns, bond and protection order conditions. Because this is a felony trespass charge, I assert my right to a preliminary hearing under Colorado law. The charged offense requires a knowing unlawful entry under CRS 18-4-502. The state's own evidence shows I produced a key, identified my mail, and handling my belongings openly. That conduct is inconsistent with a knowing unlawful entry and instead reflects a claim of lawful access. I need to note for the record that both CSPD office and the magistrate during advisement expressly found that there was no forced entry into the residence. CSP arrested me based on a name match and treated property in the residence as belonging to another person, creating confusion as to the identity of the person actually alleged to have committed the offense. I had a key to the residence, received mail there, and am married to a resident of the home. I understood the protection order applied to my stepson, but not the residence. The state initially pursued a violation of protection order and declined that charge. That decision reflects the absence of evidence that I knowingly violated a restriction. The same knowing element is required here. Also, the advisement was conducted by video while I was in custody, and I was not provided any meaningful opportunity to consult privately with counsel. I was in a shared custodial setting and could not communicate confidentially. That impaired my ability to understand the proceedings and protect my rights under the 6th Amendment to the United States Constitution and the 14th Amendment to the United States Constitution. But I'm not asking to invalidate the proceeding, but I am asking the court to hold on one second here. To take that limitation into account when evaluating the reliability of the process and the current posture of the case. I move to strike the domestic violence designation per CRS 18-6-800.3. This designation is factually unsupported as there was no physical harm, injury, or verbal threat. Regarding the property, I move for an order under Colorado Criminal Procedure Rule 41E, wherein the officers conducted a warrantless transfer of my property to a non-owner and restrained party without providing an inventory or receipt, violating due process. I request a full accounting and the immediate restoration of my belongings. If such an accounting cannot be provided, I move for damages in the amount of $5,000. Finally, since the court previously found no forced entry and the VPO has been dismissed, the basis for the current bond and the trespass charge is void. I request the immediate conversion to a PR bond and release of my funds. And based on those factors, I respectfully request dismissal for lack of probable cause.
Okay. Let's start first things first. Given the nature of the charge, which is a Class 6 felony, and you are out of custody, you are no longer entitled to a preliminary hearing. A lot of what you have addressed is factually based that would be determined most likely by a jury at the end, if we get to that point, setting the matter for trial and having a jury determine whether or not the alleged facts were done as an act of domestic violence, which, just for the record, goes beyond just an actual act of violence, but include acts done as methods of coercion, control, or retaliation. And so whether or not the domestic violence tag applies would be determined by a jury if, in fact, this matter is taken to trial, with a specific interrogatory being asked of the jury to find that the prosecution has proven beyond a reasonable doubt that any act constitutes a act of domestic violence. As to the factual basis, as to whether or not you believe the charges support the allegations that have been filed against you, again, you are not entitled to a preliminary hearing. A judicial officer has already made a determination that there is probable cause to find that you did the acts as alleged. And again, to the extent that you are either not offered or choose not to take any plea agreement, that would be addressed by a jury as to whether or not the prosecution has proven beyond a reasonable doubt that you committed the charge of trespass as a Class 6 felony. With regard to any evidence that was secured by law enforcement, to some extent, that may depend on as to whether or not such evidence or those items were secured and are going to be used as evidence in the case. I just don't know enough about this to know otherwise. So what I'm going to do at this point in time, noting that you have preserved all your objections, is I'm going to set this matter for a dispositional hearing, unless you're wanting to enter a not guilty plea today. I don't know. But my suggestion would be is that you spend a few moments speaking to Mr. Libby. He can advise you as to how you can get the discovery, the evidence that the prosecution has against you, that you can go over to the district attorney's office to get that information. And then also at the next court date, we will know who specifically your advisory counsel is, and they can also further advise you as to how to proceed in this matter procedurally, noting that if you take the matter to trial, you would have advisory counsel with you. But again, as you are aware, they would just be advising you procedurally how to go forward. You would be the individual who is actually conducting the trial. So we'll give you a new court date here in a moment.
And you said the preliminary hearing was, I couldn't have one.
You're not entitled.
Not entitled to one because of what now?
Because of the element of the charge and I should say the level of the charge, and you have bonded out. If you remain in custody, you are always entitled to a preliminary hearing. It changes a little bit once you have posted bond. But I'm going to give you a new court date here. And then we're going to set that about 4 weeks out. And if you just want to spend a few moments speaking with Mr. Libby, unless you already know how to get your discovery.
So, Your Honor, I'd be happy to speak to Mr. Smith for a discovery. I don't believe it's been quite yet.
Okay.
But there is a process for that. And then regarding advisory council, we haven't not yet, but we had anything about.
So we're going to appoint Mr. Allen as advisory counsel. If Mr. Allen is appointed as a county court judge, then we will have to change that.
Then Your Honor, I'm solo this morning, so I just stepped out to speak to Mr. Smith.
Yep, we'll allow you to do so.
Our next court date's going to be May 20th at 9 a.m.
Yeah.
Can we start going through the plea?
No, we'll wait.
Sir, so. Your Honor, thank you for the break.
Yep.
Just for the record, I've spoken to Mr. Smith. I received this email, maybe sending him some detailed instructions regarding discovery. I let him know I'll be sending those probably around lunchtime today. I'm sure they're comprehensive.
Okay.
We're also going to set the time to speak about the case. I let him know that I'd be moving in his advisory council on communications, whatsoever it ultimately ends up being. Mr. Smith, I think.
And only because there's been some conflict between myself and the bondsman, wherein I've pretty much been threatened to that my bond would be revoked. That I was requesting a emergency PR bond. I've since my release, I've been to court, not a threat to myself nor society. Again, the DV designation is just an enhancer. There was no physical threat, injury, hurt, harm, or verbal threat to anyone. And so based on those grounds, I'm requesting a PR bond.
Well, again, for purposes of addressing bond where there has been allegation of domestic violence, again, understanding reserving all your arguments as to why you do not believe that domestic violence tag should be appropriate. This is a VR Victims' Right Act matter. The victim would have the right to address the court as to whether or not this should be converted to a PR bond. I'm not, if your bond gets revoked, that is something that we could address at a later point in time, but the court's not going to revoke your bond or convert the cash surety bond to a personal recognizance bond at this time. But if that later, if something changes to where your bondsman asked to get off the bond, we can address it at that point in time. All right. So
But my only concern is that if the state cannot provide the evidence of my knowing intent today, then.
But sir, all those elements have to be addressed. Those are elements of the case, which because you're not entitled to a preliminary hearing on the element of knowing, that is either resolved by way of a plea agreement or it's resolved by way of a trial as to whether or not the prosecution can prove that element.
Okay.
So,
Understood.
but I appreciate you raising those issues and we can address them at a later point in time.
Thank you.
Thank you, sir.
All right.